This case is a perfect storm of second chances, broken trust, and a judge who's clearly running out of patience. We're looking at Roxan Hutchinson, a woman already on probation for a felony weapons charge, now back in court after allegedly violating that probation by committing a brand new offense, theft. And here's where it gets intense. She admits it. No trial, no denial, just a straight-up plea of true. But this isn't just about one mistake. This is about a pattern. The court is now faced with a critical decision. Do they give her another opportunity through treatment and rehabilitation, or do they send her straight to prison for up to 10 years? And there's more at stake here than just time behind bars. Roxan is also fighting to regain custody of her 4-year-old son through CPS. So now the question becomes, does the court believe she's truly trying to change, or is this just another cycle repeating itself? Pay close attention, because what unfolds in this courtroom isn't just about the law. It's about accountability, redemption, and whether the system still believes in second chances. Let's get into it.
I'm not following the agreement that you all have reached on this motion to revoke.
I'm just asking for a chance to get treatment and not go to prison. I do have a 4-year-old son that I'm fighting for.
The state of Texas is willing to give her an opportunity, so I'm re-urging the court to give her that opportunity. She's not asking for you to release her. She's asking you to send her to.
Right. Why is the only tangent thing that I see from you is that you're picking up a new charge? Grant the motion to revoke. All right. Court is calling 2024 CR 007-949 State versus Roxan Hutchinson. Can I have parties announce?
I can gallery to see it. We got from the defense.
And are you Roxan Hutchinson?
Yes, ma'am.
All right. Did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Roxan Hutchinson who was placed on community supervision in 2024 CR 007-949 for the offense of unlawfully carrying a weapon with a felony conviction for 7 years on November 7th, 2024? Is that you?
Yes, ma'am.
All right, state.
Yes, Jeff. Are proceeding with violation of condition number 1 on or about the 19th day of February 2025 in Bexar County, Texas. The defendant, Roxan Hutchinson, committed the offense of theft in violation of condition number 1.
How do you plead to that? True or not true?
True. The state will waive and abandon the remaining violations, Your Honor.
Any objections?
No objections, Your Honor.
All right. Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, grant the motion, and sentence you up to 10 years in the prison?
Yes, ma'am.
And up to a $2,000 fine. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to proceed with your violation of condition number 1 in your plea of true?
Yes, ma'am.
Let's pause right here because this is a critical legal moment. When Roxan pleads true to violating condition number 1, she's essentially admitting to the violation without forcing the state to prove it. That gives the judge full authority to revoke her probation immediately and impose any sentence within the original range, which in this case is up to 10 years in prison. Now here's the twist. Despite that admission, both the prosecution and defense are actually recommending that she stay on probation with stricter conditions like intensive treatment programs. That's rare. When both sides agree on leniency, it usually signals that they believe rehabilitation is still possible. So now the pressure shifts entirely to the judge. Will she follow the agreement, or is she seeing something deeper that the attorneys might be overlooking?
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and it would involve the following case, which there's plea paperwork before the court for the same defendant.
Yes.
The state probation and believe defense's recommendation is to continue probationer on this probation in cause number 2024 CR 007-949, but to amend conditions to now include state ISF, cognitive track, followed by ISP. And probation did make a note upon disposition of pending cases, the plea paperwork on cause number. Well, I see at 2025 AL 002862, there's a cause number I don't see right now, but those conditions would also reflect and run concurrent with this cause number.
All right, what has she done on probation?
Judge, the only thing that Ms. Hutchinson has done on probation has been to provide her DNA sample as required.
She was recording, sorry.
She was reporting. She reported last May 7th of 2025.
Now this is where things start to unravel for the defense. The judge isn't just looking at whether Roxanne showed up or checked a box. She's digging into effort, consistency, and accountability. And what we're hearing? Minimal compliance. Yes, she reported. Yes, she submitted DNA. But where's the progress? No stable employment. Parenting classes only through CPS, not independently initiated. And most importantly, she picked up a new charge while already under court supervision. That's a major red flag. From the judge's perspective, this isn't someone fully committed to change. It's someone doing the bare minimum while continuing risky behavior. So now ask yourself, if you were in that seat, would you trust this pattern to suddenly reverse?
She had been reporting previous to that as well.
Right. I'm saying her last reporting is on that day.
All right. So here's my question. Has she done her parenting classes? All right. Did she obtain employment?
Judge, if I may
Yes.
inform the court, she was doing the parenting classes through CPS. She has a CPS plan because she's trying to get her child back through CPS. So she's doing the CPS classes through CPS. She has a CPS plan. So she's going through CPS. So she has a CPS plan. So she's doing her parenting classes through CPS.
All right. So how long has the CPS case been open? Was it open before this case?
Yes, ma'am.
So I don't understand why the court has received the new number one. She knows she has a CPS case, but she's picking up a new charge and she's not following through with the conditions of the court. I don't understand why I should follow the agreement to continue her.
Judge, I think she wants to
All right.
address the court.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Roxan Hutchinson.
All right, why is the only tangent thing that I see from you is that you're picking up a new charge?
Hey, I know it doesn't reflect in the probation report or whatever, but since then I've kicked heroin. I've been sober for 9 months. I do admit that the issue wasn't me just getting sober. I got sober, but I was still doing the same things that an addict does. I was hanging around the same people. I didn't change my surroundings or my friends. So I continued to do the same things. I'm just asking for a chance to get treatment and not go to prison. I do have a 4-year-old son that I'm fighting for.
This might be the most emotional moment in the entire hearing. Roxanne is finally taking accountability not just for the crime, but for the lifestyle that led to it. She admits that getting sober wasn't enough, that she stayed in the same environment, around the same people, making the same choices. That kind of self-awareness can be powerful. But here's the harsh reality. In a courtroom, timing matters. And for the judge, this realization may be coming too late. Also, notice how she brings up her son. That's not just emotional, it's strategic. She's trying to show the court that she has something worth fighting for. But the judge flips that narrative, questioning why that motivation didn't stop her from reoffending in the first place. So what do you think? Does this sound like genuine growth or damage control under pressure?
All right, so here's the thing. I don't understand why people don't think of their children before they pick up new offenses. I'm not following the agreement that you all have reached on this motion to revoke. I'm going to grant the motion revoke. Does anybody want to speak to time? She's looking at a maximum of 10 years. All right, yes.
Judge, I'm going to re-urge the court to consider following the recommendation from probation and what the state originally wanted. Ms. Hutchinson is before the court. She verbalized that she needs help. She's asking the court for help. It's not often that a defendant is before the court and they are asking the court for some help. She is asking for help also with CPS so that she can get help from CPS. It's well known that addicts relapse. That's not uncommon. And that's what happened with her. And because that happened, she picked up other offenses. The state of Texas is willing to give her an opportunity. So I'm re-urging the court to give her that opportunity. She's not asking for you to release her. She's asking you to send her to inpatient treatment so that she can get some help. That's what she's asking. And so I'm re-urging the court to consider that.
And just like that, the judge makes her decision. Despite both sides urging for treatment, she rejects the agreement and grants the motion to revoke. That means Roxan's probation is officially over, and now she's facing real prison time. Let's break down the sentencing phase. The prosecution suggests around 5 years. The defense asks for 2, and the judge lands right in the middle with 4 years in prison. That's a calculated move. Not overly harsh, but definitely not lenient either. What's interesting is that the judge still recommends therapeutic treatment within the prison system. That tells us something important. This isn't purely punitive. The court still recognizes the need for rehabilitation, but believes it has to happen behind bars, not in the community. So the message here is clear. Opportunities were given, but they weren't taken seriously enough.
All right. The court, as previously stated, is finding violation condition number 1 true, and the court is going to grant the motion to revoke. Does anyone wish to speak to time?
I believe that we will be going open on that. The state understands defendant is facing up to 10 on this MTR. The other case that will be before the court shortly had thoughts. Basically, the state is thinking, we pled true to number 1, you're facing 5 or facing 10. State would ask for around 5, Your Honor.
All right.
Judge, we're asking the court to sentence Ms. Hutchinson to 2 years in TDC.
All right. This is what the court is going to do. The court will sentence you to 4 years in the prison. The court will request the therapeutic community. The court will give you a credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes, please.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do y'all want to reconsider the plea bargain agreement with the theft case?
Yes.
Are there applications in this case?
No, Your Honor.
Did you understand you're charged with theft of property less than $2,500 with 2 or more previous convictions as state jail felony?
Yes, ma'am.
Just one moment. Are you all waiving?
No, Your Honor, we are proceeding with the repeater to make this a 3rd-degree punishment range.
All right, thank you.
Yes, Judge.
If you all could write the repeater on here, please. All right, do you understand if the state approves of the repeater enhancement paragraph, then this will be a 3rd-degree felony. The range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
According to the plea, the state is proceeding on count 1. And is she going to agree that she's been previously convicted for purposes of enhancement?
Once we get to the stipulations.
If y'all would check the box. You further agree that you've been previously convicted of 1 or more felonies for purposes of enhancement. Your punishment is to be assessed at 4 years in the prison. This will run concurrent with 2024 CR 007949. They were taking consideration 2025 CR 007240, 2025 PF 26020. There's to be restitution of $60 and to the Bexar County Crime Lab, and 2025 PF 26020. There's to be no contact with the complaining witness. Did you understand that to be your new plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Judge.
Then defense is charged. How do you plead? Guilty, not guilty, or no contest?
No contest.
And I'm sorry, to the enhancement, how do you plead? True or not true?
True.
All right, after reviewing State's Exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
And I'm sorry, and also the court will find the enhancement true based upon your plea of true and based upon State's Exhibits 1 and attachments. Anything you wish to say on behalf of your client?
Judge, we're asking the court to follow the recommendation of the ADA and run it concurrent with the motion to revoke.
All right, the court will sentence you to 4 years in the prison, give you credit for any time served. This is to run concurrently with 2024 CR 007949. State will take in consideration 2025 CR 007240. Restitution to...
This case is a powerful example of how quickly second chances can slip away when patterns don't change. Roxan Hutchinson was given an opportunity, probation instead of prison, but after admitting to a new offense and showing limited progress, the court ultimately decided that enough was enough. The judge sentenced her to 4 years in prison, rejecting a joint recommendation for continued probation and treatment. Even though Roxan showed moments of honesty and self-awareness, the court prioritized accountability and public safety over another chance in the community. At the same time, the inclusion of therapeutic programs within the prison system shows that rehabilitation isn't off the table, it's just being enforced in a more controlled environment. Now the question is, was this the right call? Should the court have leaned into treatment instead of incarceration, or did Roxan run out of chances? If you found this case as intense and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Bexar County Lab. All right, good luck to you.